This is my absolute favorite topic. If you're new to importing, the process is so easy. Find a great broker. There are many. Your broker will help you get your account set up with customs and find you a great surety, and voila, you're ready to import, right? Wrong. Throughout this simple process, no one sits down to tell you the hard truth. You, as an importer of record, are the responsible party and have many responsibilities and liabilities. So I'm going to share the truth with you today. A U.S. importer of record has vast legal obligations to meet, including ensuring they have a process in place to prove that they have used reasonable care. That is the correct customs term, reasonable care. And reasonable care is important to properly identify the classification, valuation, country of origin, free trade agreement use, and use of intellectual property rights. Customs has vast resources to assist you in understanding your responsibilities as a U.S. importer, and Customs expects that you've read all of them. Reasonable care is a somewhat subjective standard. However, Diaz Trade Law provides pre-compliance assistance to make sure you're on the right track and have the right pre-compliance standards in place. The first question Customs will ask is whether or not you've retained an expert to assist you in complying with your reasonable care requirements. If the answer is no, and you want to import, you need to get an expert, or the penalties for non-compliance can be severe. Customs uses various tools to test an importer's compliance. The first notice that you see is typically a request for information. U.S. Customs often verifies that an importer is declaring the merchandise entered into the U.S. properly by using this form, the request for information. It's extremely important to ensure an expert is responding on your behalf, and I'll tell you why. This is especially so if, when you receive this request for information, you realize, as an importer, you've made an error. It's an inadvertent error, but an investigation has not yet taken place by Customs. Well then, we have the opportunity to file a prior disclosure, which can assist you in drastically reducing penalties from Customs. Only if it's a perfected prior disclosure. You only want a customs expert to assist you with this process. Imagine filing a disclosure that's not perfected and getting penalties anyways. Your goal is not to receive any further forms from Customs, and most importantly, no penalties. Diaz Trade Law provides expert analysis of your import transactions to determine if a prior disclosure can and should be filed. Most importantly, we ensure that if a prior disclosure is filed, it contains all the necessary elements to be accepted by Customs. If Customs is not satisfied with your answers to the request for information, you're going to receive a notice of action that looks like this. It's essential that importers contact Diaz Trade Law upon receipt of a notice of action, as wrong responses often lead to penalties if you don't deal with it properly or timely. If U.S. Customs takes action you don't agree with in response to your CBP Form 29 response or notice of action, you have the right to file a protest with Customs. The time frame is extremely important. You only have 180 days after liquidation to file your protest with Customs. The rationale of a protest is to contest U.S. Customs' final decision. And remember, that would be relating to the classification, valuation, country of origin marking, duty preference program or free trade agreement used for the imported merchandise. On the protest form, you also have the right to request further review. Make sure you do. 19 U.S.C. 1592, this is the statute that Customs references when issuing penalties. The penalties will be for negligence, gross negligence, or fraud, depending on the degree of culpability Customs believes you had at the time of your non-compliance. This is a sample penalty notice. Note that the law violated is 19 U.S.C. 1592. In this case, I filed a petition with Customs, and Customs mitigated the penalty in full. If you receive a penalty from U.S. Customs, contact Diaz Trade Law today. We have successfully helped numerous companies mitigate penalties from Customs for claims of negligence, gross negligence, or fraud under 1592. My name is Jennifer Diaz, and I'm a board-certified international attorney, an expert in penalty cases. I'll discuss your options with you, including filing a petition with Customs and working on pre-compliance for future importations. If so, pre-compliance is key. Diaz Trade Law prides itself upon creating custom pre-compliance programs targeted for your specific needs and includes all of your reasonable care requirements. The end goal is to expedite your supply chain with your very own custom compliance program. Oftentimes, this will also encompass taking advantage of voluntary compliance programs in place. For example, CTPAT. For example, after successfully resolving a customs seizure case, I assisted a major electronics importer with developing their very own pre-compliance plan. The plan entailed reviewing intellectual property rights issues prior to importation and proactively reporting the same to Customs, thereby expediting their supply chain. I love teaching my clients and providing customized training programs that are feasible for both small and large companies. You can see more successful past results at diaztradelaw.com. Every case is different and each must be evaluated on its own merit. I would be pleased to discuss your current or future importation and help you come up with your own customized training and pre-compliance plan. I have many blog posts on this topic as well at diaztradelaw.com. Let me be your customs and international trade law expert. For more information, please visit diaztradelaw.com.